Hello, Stuart Richland here from 420lawoffice.com and here on the YouTube channel. Well, the harsh reality is certainly beginning to sink in for so many of the patients here in Los Angeles that their treasured collectives, their association that they trust and have come to know, that have medicine that works for them and people that have counseled them and that know them, may be closed. In fact, the effective date of Prop D is the date of the election. So technically, any collective that is not exempt has to close. So although some people are a little bit slow to have this dawn, the reason that I and my colleagues have been burning the midnight oil is because we recognize that any minute collectives are going to need injunctive relief to stop the effectiveness of Proposition D. Now, why might Prop D on its face be defective, and then why might it be defective as applied to your collective, and how can I and my legal team be of assistance to you? Well, let's talk about on its face. You'll note that the proposition requires that only those collectives that registered back in 2007 and also who registered pursuant to the limited immunity secondary ordinance that they did last year are qualified to stay alive, to stay open. Now let's think about how legally appropriate or fair that is. Okay, to start with, the ICO that was effective back then in September 2007 actually was ruled unconstitutional. Judge Chalfant ruled that it was on its face constitutionally improper because temporary urgency ordinances can't have time frames more than 45 days. And remember, the registration period was over 60 days, and the whole thing was invalid. So therefore, the Prop D reliance on an old invalid act done pursuant to an old invalid ordinance is misapplied. Because that ordinance was invalid, it was void ab initio, it's as if it never existed. So gauging people's compliance with a void rule as being a test for whether or not they can exist is unfair. Let's talk about the next hurdle, the limited immunity registration that had to be done last year. That was the one that the people themselves voted to declare invalid. Remember, there was a people's plebiscite, and by vote, the people determined that that was not going to be the law here in the city of Los Angeles. Simultaneously, my firm and some other firms brought some lawsuits. We dismissed them because they were moot. But that whole ordinance, the second hurdle, was again void. It was withdrawn by the city council, as you'll remember, in light of or based upon or due to the very effective signature gathering and activity of people that realized that it was a bad law. Okay, so now we see that this new Prop D relies on two hurdles, both of which are improper and unconstitutional. And I could go on and on. There are many, many levels of failure on Prop D to be a constitutional ordinance and to follow requirements of law. Because of those failures, I believe that your collective, depending on the facts of your collective, may have a reasonable good shot and certainly a good faith claim that the proposition should not apply to it as applied, and also, if quickly done, I believe that's got to be within 60 days of the effective date, a challenge on its face, which would invoke a challenge just on the basis of the language of the ordinance. Either way, in order for you to benefit primarily as a named beneficiary of an injunction or a named beneficiary of a court order that protects your rights, you need to be named in such a lawsuit. There is only one form of action in the state of California. If you have a grievance, there is the lawsuit. And that is the single civil form of action, whether it's called a petition or a lawsuit or a divorce or a dissolution or a personal injury case or whatever. There is just one form of action. It's the lawsuit. So don't be scared of that word. It's the way that we bring jurisdiction to a judge to review the law to make sure that it's constitutional. It's not a matter of hard feelings. It's a matter of utilizing reasonable legal tactics that must be based upon a good faith presentation, and you can't just challenge to challenge. But having reviewed the law, it is a good faith challengeable ordinance. And so the request is out, or the invitation is out, clients. Many of you have contacted me already. The pricing that I can offer you will be based upon how many contact me. So far it's only this many. 3 pages of notes, maybe 14 collectives plus my old standards, maybe about 20. So let's expand that number a bit. Let's come up with a nice number so I can give you guys a nice price. As I've let you know, it's myself, Graham Barry, and Stan Kimmel. I really have to tell you, these are lawyers I'm very honored to be working with. I can't wait to do a video presentation with them. There's already something online with me with each of them, and you can check those out at 420lawoffice.com. We'll be doing a lot more to continue to show you some of the aspects of Proposition D which are unconstitutional, and we want to be the lawyers to bring those charges and those claims for you before an impartial neutral, the judicial branch, a judge, to determine whether we can get an injunction to stop your collective from being shut down. Thank you very much for touching base. I'll see you soon. Check out Legal Team Fights Prop D on Facebook, and please join us. I am so pleased to be in the battle with Graham Barry, veteran of the battles with Scientology, and a 38-year practitioner, a kick-ass lawyer, and Stan Kimmel, former city attorney, an amazing civil attorney, someone who knows procedure, someone who cannot be messed around with when it comes to municipal code, health and safety code, court arguing. Can't wait to be doing it all together with them. We're calling it Legal Team Fights Prop D. By the way, I'll take the Pepsi challenge with any other attorney on my comprehensive 1-hour consultation on medical marijuana law. I'd be very happy to give you my book and walk you through it. Just to give me a call and we'll book your appointment. It is $500, and I also have an upsell, which is my $1,000 do-it-yourself corporate kit. Thanks very much for touching base.